All right, topic number two, and that topic is intellectual property. Um, Intellectual property, which is IP for short, is one of my favorite topics, so I could certainly talk to you guys about IP all day. But in this short video, what I'll do is just highlight the four main areas of intellectual property and how that applies to artists and their artistic practices, and then I'll talk a little bit about copyright. So, of the four main types of IP that I'll talk about today, I want to start with trade secrets. Trade secrets are one of the lesser known forms of intellectual property, um, but they're very powerful. Trade secrets are very powerful and are often considered some of the most important and the most valuable IP that a company has. So the idea of a trade secret is that trade secrets can include everything from your methodologies, your processes, your client list, your collector list, it's your know-how, it's data, it's databases, it's all of that type of information that you use to be able to, for instance, support your studio practice. So it's even techniques that you might have developed, it's things that you may technically want to keep confidential because that information may be your secret sauce. If you ever heard of secret sauce, it's typically referring to IP. That's very popular terminology that's passed around in the startup space. Investors will ask, well, what is your secret sauce? They're talking about intellectual property. And oftentimes they're talking about things that are trade secrets. So it's your art practice, it's your methodology. Again, it's the way that you go about doing what you do. So, for instance, I have a client that has a pretty extensive practice in terms of how they make their visual work. They're working in 2D, but they have developed a process. They do time lapse videos of their process. They, give workshops on their process. So it's not necessarily secret in that they don't show anyone. But there are some things that they don't film, or there are some details that they may leave out about how they do what they do. And that would be considered a trade secret. So, this comes up more often with artists who are working in 3D. There may be some techniques, some things that you've developed to work in a 3D environment that could be considered a trade secret. So that's your art practice and methodologies. So those are trade secrets. I should mention that trade secrets are protected within a lattice work of law. There's state law, there's law that each state passes that can provide some trade secret protection, but there's also federal trade secret law, meaning law that would be dealt with, of course, that are in like the federal circuit courts dealing with trade secrets. But the main point is that you protect trade secrets by keeping them secret. And artists do that by making sure, for instance, if you're collaborating with someone, that you have a confidentiality agreement or a confidentiality statement. This comes up very often when artists are approached for projects or collaborations. They'll start to talk about their idea, they'll start to talk about their project or their program, but they don't really have any agreement, or they don't even have anything in an email stating that what they are sharing, for the purposes of having a conversation, they don't mention that that work or those ideas are confidential. So those fall within the world of trade secrets. And as long as you take steps to keep things confidential, trade secrets are sort of free to maintain beyond the research and development. So copyright is the segment of intellectual property that most artists are familiar with, if they're familiar with IP at all. So copyrights protect the fruit of your creativity, in that it protects what you make as an artist, as long as that idea comes out of your mind and you fix it in something that's tangible. So if you have an idea about a scene that you'd like to draw, you take that, put that idea in your hand, and then you draw. The moment you make that drawing is something that would be protected by copyright law. So copyright law is mostly a function of the federal law. So there's the U.S. Copyright Act that provides the bulk of copyright protection. But copyright protects paintings, Photographs, as I mentioned, sculpture, jewelry designs to the extent that they're highly creative and not just geometric. Copyrights can protect film, protect animations. Copyrights are very important in the virtual worlds as we see more intersection between art and technology. Copyrights become important there. A lot of people, most people are familiar with copyrights as it applies to music, and their entry point to that knowledge comes from royalties and understanding how musicians get paid. Copyright protects poems, it protects literary works and books and blogs and websites. Copyright also protects choreography, right? So for the dancers who are joining us, there's also copyright protection for choreography, and there's actually been some interesting cases dealing with certain dances and dance moves and dance sequences being incorporated in the video game space. So the point is that copyright typically is the bulk of the protection for artists because most of what artists are creating falls within the realm of copyright. So copyright, we'll talk about registration in a minute, but in terms of the cost to maintain and to register copyrights, it's not free. There is a cost to register at the U.S. Copyright Office, but it's the least expensive of the three other types of IP that we're getting ready to talk about, where you do need to register. So that's copyright, and we'll revisit that in a minute. There are also trademarks. So trademarks are important and they're becoming even more important as time goes on because a lot of artists are seeing themselves and seeing their work and their practice as a brand. Artists are being contacted by and are entering into contracts with entities who are reaching out to the artist because of their brand. And when I say brand, I don't mean just the artistic practice, like how the artist does work or what the artist is known for in terms of their medium. I'm talking about brand as in how they present themselves to the marketplace. So there are many artists that are managing their brands or even thinking about themselves in that way. And so these are artists who are a little bit more on the commercial side. But nevertheless, it's important to know about trademarks. So trademarks protect brand names, logos. They can protect even your signature. There are some folks who protect their signature as a brand. Any sort of taglines. People get trademarks for hashtags. Trademarks protect many different types of things. But the point with trademark is that trademarks are a function of federal law, but also trademarks are hyper focused on commerce. So it's all about using trademarks, using those marks in the marketplace as they apply to you selling work or selling physical objects, goods, or selling services. So whereas copyrights sort of exist as something that protects the fruit of creativity in and of itself, like because it exists, trademark is different. Trademark is all about commerce, and the idea is that the United States Patent and Trademark Office, the USPTO, will give certain applicants the right to own a certain logo or own a name or own a tagline. And that ownership right gives that entity or that person the ability to keep other people from using those trademarks as they apply to putting products and services in the marketplace. So trademarks are really interesting with the intersection of art and technology and virtual worlds and video games and all of that. Issues with trademarks come up there as well, particularly if you're having like some interaction between avatars within like a video or virtual environment, and then they're interacting with actual products and services that exist in the real world. Trademarks definitely come into play there. But I wanted to mention trademarks to you guys so that you know about this aspect of intellectual property. So trademarks are more expensive than copyright. In fact, the filing fee for a trademark, just for one trademark for one type of service, is triple the cost of filing for one copyright application. So typically when artists are pursuing trademark protection, it's because they've established a brand and they want to protect that brand. So that there is some market difference, like a difference between what they're doing versus what other folks are doing. And so the third well, fourth aspect of intellectual property, with the third one we'll talk about today that includes a fee to participate, are patents. So I want to mention patents. Oftentimes it's interesting, like trade secrets is on one end, patents are on another end, where artists may not necessarily be thinking about the usefulness for their artistic practice, but patents are the most expensive of the intellectual property, also a function of federal law. Same idea with trademark in that the USPTO is giving someone the ability to control what happens with a patent. And there's different types of patents. We see them a lot in the world of fashion. We're seeing them in the world of wearable tech. We're seeing them again in the virtual spaces where we have algorithms and different types of ways that artists are creating solutions or creating art. A lot of that falls into the world of patent. And an example of patents, I don't think you guys would have this time, but you can go to Google patents and search for art and see what comes up. It's pretty interesting. But a patent could be an art application tool, right? You'd be surprised how many physical art application tools are patented, or formulations, or just all sorts of things. I was working with an artist who had taken a very common tool and modified it in a way that this tool enabled the artist to create murals with a certain technique. And so one of the questions was, can you get a patent for that? And the answer is most likely yes, for a cost. But I just wanted to bring that up to you guys, because you never know. You could be actually inventing things that are new and novel, something that could be protected by patent as you're just going about your daily artistic practice, which I think is pretty neat. So back to copyright, and this kind of brings us to the end of this short segment on intellectual property. I wanted to revisit copyright. So we talked about the different things that can be protected by copyright, but I want to go over 4 points. The first is that copyright exists from the moment of creation. So what that means is, again, if you have an idea in your head and then you take that idea out of your head and you draw, you take a photograph, you sculpt, you take that idea and put it into something tangible, that's the moment in time the copyright exists. So there's a difference between the creation of a copyright and the registration of a copyright. For trademarks and patents, it's all a matter of registration. You can have something that's protected by trademark or patent. And for trademark, you have some rights that you can avail yourself of, and for patent, under state law, but really the bulk of the protection comes from, and your ability to control what happens for trademark and patent comes more with your registration. Copyright's a little bit different. Again, the point of copyright is to protect something that's copyrightable, like a photograph, from the moment it exists. So that's an important distinction. The other thing is, each copyright that you have actually has multiple rights. So the way that I explain that is that if you have one copyright, this one copyright can be divided. This one copyright gives you multiple rights. It gives you multiple things that you can do in terms of keeping other people from using your work. Or when we talk about licensing in a minute, you can license out these various rights. So one copyright actually equals multiple rights that you have. Registration of copyright does have benefits, and the main benefit is that in order for you to avail yourself of the federal court system for copyright protection when it comes to infringement. Infringement is when someone uses your work without your permission. The only way to get to federal court is to have a registration. So there's often questions about, well, I have copyright, I have works that I've created, when do I register the copyright? I'll give a couple of examples. If you have a set of paintings that you've been working on for a while, and maybe some collectors have some, maybe you have some in your studio. The point where you maybe those paintings are or high-res images of those paintings are published in a book or an exhibition catalog or a publication, or the moment those paintings go on tour and for an exhibition, that might be a point in time where you want to register the copyrights. And there's certain ways to do that at the U.S. Copyright Office. I have worked with clients that are, one in particular who's a photographer, and this photographer is a commercial photographer. They have both a commercial side to their photography business as well as a fine art side to their photography business. This particular photographer has a very robust stream of income from the commercial side. And so what this photographer does is works with an assistant to register copyrights like on a scheduled basis once a quarter. So they pick a day once a quarter and they just register all of the copyrights for all of the photographs that have been taken in that quarter. So that's another example of how you can manage registration versus creation. But you can think of it as, you have a baby, right? A baby exists, right, before you get a birth certificate. So you could think of the baby as the copyright, and you could think of a copyright registration as like a birth certificate. The baby precedes the birth certificate. But you certainly need the birth certificate to do a lot of different things, right? To be able to avail yourself of all kinds of stuff that are helpful to the baby. Same thing with copyright registration. Registering your copyrights allows you to be able to protect the copyrights in the federal courts. In case there is infringement, which is the fourth point, and that is any unlicensed use of a copyright is infringement. That's statutory law. So I have people ask me questions like, well, is it true that I can use like 10% of what somebody else... There's a lot of like myths out there about these percentages. I don't know where any of this got started, but that's not the law. It's pretty simple in that if you are using something and it's unlicensed, it's most likely going to be copyright infringement. So talking about issues such as fair use are beyond the scope of this particular video, but there are some other policies, some other things that come into play to help artists. But those are the four main points I wanted to share with you regarding copyrights and regarding intellectual property in general. So this is the end of video 2, and I will see you in our final video, video 3.